United States citizenship is one of the most powerful legal protections on earth, and most people believe that once they have it, nothing can ever take it away. That belief is dangerously incomplete. Right now, in 2026, federal agencies are reviewing cases, cross-referencing records, and flagging files that sat untouched for years. The mechanisms that can strip someone of their citizenship have not changed overnight, but the enforcement behind them has accelerated in ways that most people have never been warned about. And the most unsettling part is this: the people most at risk are not criminals, they are not spies. They are ordinary individuals who made decisions they believed were perfectly normal, sometimes decades ago, without ever realizing those decisions now carry consequences that reach all the way to their legal identity as Americans. Nothing about this process announces itself loudly. There are no sirens. There is no knock on the door at midnight. What happens instead is quieter. A letter arrives. A passport renewal gets denied. A routine background check surfaces something that was buried so deep the person forgot it existed. And from that moment forward, the burden of proving you deserve to remain a citizen falls entirely on you. Most people assume citizenship loss only happens in extreme dramatic situations: treason, espionage, acts of war. And while those cases do exist, they represent a fraction of the real picture. The situations that catch people off guard are far more subtle and far more common than anyone expects. They involve paperwork, timing, associations, and decisions that felt harmless at the time they were made. What makes 2026 different is not that the law itself changed dramatically. It is that the systems designed to detect, investigate, and act on these situations are now faster, more interconnected, and less forgiving than they have ever been. Data that once lived in separate government databases is now linked. Agencies that once operated independently now share information in real time. And reviews that once took years to initiate can now be triggered automatically. If you are a United States citizen, whether by birth or through naturalization, understanding how citizenship can be lost is no longer optional knowledge. It is essential protection, because by the time the system reaches your file, the window to prevent what happens next may already be closing. Hi, I am Sophia, and I have spent the last several weeks reviewing federal policy updates, Department of Homeland Security bulletins, State Department procedural changes, and legal case records to understand exactly how citizenship revocation works in 2026 and who it affects. This is not legal advice, and it is not speculation. This is a clear, calm breakdown of the mechanisms that are already in place, already funded, and already being used. My only goal is to make sure you understand what the system can do before it does it to you. The reason most people never think about losing citizenship is because the process is invisible until it becomes personal. And by the time it becomes personal, the options available to you have already narrowed. So let us begin with the situation that surprises more people than any other, because it does not involve any wrongdoing at all. It involves a choice. Every year, a small but growing number of Americans walk into a United States embassy or consulate abroad and formally declare that they no longer wish to be citizens. This is called renunciation, and it is the most straightforward way a person can lose United States citizenship. But what shocks many people is not that the process exists. It is how permanent, how irreversible, and how far-reaching the consequences truly are. Renunciation is not something that happens by accident. You cannot lose your citizenship because you said something in frustration. You cannot lose it because you moved abroad. You cannot lose it by posting something online or by failing to vote for 20 years. The process requires a formal in-person appointment at a United States diplomatic facility outside the country. You must sign detailed legal documents. You must take an oath confirming that you understand exactly what you are doing. And there is a fee that has increased significantly over the past decade. Once it is done, it is done. There is no cooling off period. There is no reversal procedure. There is no coming back. You lose the right to live and work freely in the United States. You lose consular protection abroad. You may need a visa to visit the country you once called home. And in many cases, you trigger what is known as an exit tax, a financial assessment on your worldwide assets that can reach deeply into savings, investments, and property. What has changed in 2026 is not the existence of this process. It has existed for decades. What has changed is how the government now handles it. Starting this year, the State Department has implemented mandatory pre-renunciation counseling. Before your appointment is even confirmed, you are required to receive a detailed explanation of every consequence: tax obligations, travel restrictions, impact on family members, loss of benefits. The intention is to prevent impulsive decisions driven by frustration with tax compliance or political disagreements. But here is what many people miss entirely. Renunciation does not only affect the person who makes the choice, it can affect their children, their spouse, and their future family members who might have otherwise inherited citizenship rights. A decision made in a single afternoon can reshape the legal identity of an entire family for generations. For most people, renunciation will never be part of their life, but understanding that it exists and understanding that it is permanent is the first layer of awareness that most citizens simply do not have. Now, there is another path to losing citizenship that operates very differently. It does not require your consent, it does not require your signature, and it does not care how long you have been an American. This is the one that keeps immigration attorneys up at night because it can surface years or even decades after the original event. Denaturalization is the legal process through which the United States government revokes citizenship that was granted through naturalization. And while it sounds rare, the infrastructure behind it has been expanding steadily and quietly. Federal agencies now have dedicated units focused specifically on reviewing naturalization files. And in 2026, those units have access to tools, databases, and international information sharing agreements that did not exist even 5 years ago. The most common trigger for denaturalization is fraud during the original application process, not small mistakes, not confusion over dates or addresses, not difficulty with English. The cases that move forward almost always involve intentional deception about something material. That might mean concealing a criminal history that would have disqualified the applicant. It might mean using a false identity. It might mean hiding membership in organizations that are designated as threats to national security. It might mean lying about marital status, residence history, or prior immigration violations. What makes this so dangerous in 2026 is the reach of modern verification. Biometric databases now span dozens of countries. Fingerprint records, facial recognition data, travel logs, and criminal records are increasingly shared between governments through formal agreements. Something that a person successfully concealed 20 years ago may now surface through a routine data exchange between agencies that previously had no connection to each other. When denaturalization proceedings begin, the case goes to federal court. The person is notified. They have the right to legal representation. They have the right to present evidence and arguments. Nothing happens secretly, but the burden is enormous. Once the government presents evidence of fraud, the individual must demonstrate that their naturalization was lawfully obtained. And if the court rules against them, the consequences are devastating. Citizenship is revoked. The person reverts to their prior immigration status, which in many cases no longer exists. Deportation proceedings can follow immediately. What unsettles many people about this process is the absence of a time limit. There is no statute of limitations on naturalization fraud. A file that has been closed for 30 years can be reopened if new evidence emerges. And in an era where digital records, international cooperation, and artificial intelligence are making old information newly discoverable, the phrase new evidence has taken on a meaning that previous generations never had to consider. It is also worth understanding that denaturalization does not only affect the individual whose citizenship is revoked. In many cases, family members who derived their own immigration status or citizenship through the naturalized person can also face consequences. A spouse who adjusted status based on the marriage. Children who became citizens automatically when their parent naturalized. These derivative benefits are legally connected to the original naturalization. And if that foundation is removed, everything built on top of it can be called into question. This ripple effect is what makes denaturalization so devastating. It does not simply undo one person's status. It can unravel an entire family's legal standing in the United States. And the people affected may have had no involvement whatsoever in the original fraud. They may have been children at the time. They may not have even known the deception existed. The Department of Justice has publicly stated that citizenship fraud investigations are a priority. Dedicated offices now handle these cases with specialized prosecutors, access to international databases, and coordination with foreign governments who share records under bilateral agreements. The infrastructure is not theoretical. It is staffed, funded, and active. For anyone who went through the naturalization process honestly, who answered questions truthfully, who disclosed their history completely, this should not be a source of fear. But it should be a source of awareness, because the system is not only looking at new applicants, it is looking backward. and it is finding things that were invisible before. There is another dimension to citizenship loss that most people associate with movies and courtroom dramas, but that exists in real federal law and has been applied in actual cases. It involves what the government considers acts of disloyalty that are so severe they constitute a voluntary abandonment of allegiance. Under United States law, a citizen can potentially lose their nationality by committing certain acts with the specific intent of relinquishing citizenship. Those acts include serving in a foreign military that is engaged in hostilities against the United States, taking a formal oath of allegiance to a foreign state, and accepting employment with a foreign government in a position that requires an oath of loyalty. The critical legal element in every one of these scenarios is intent. The government must demonstrate that the individual performed the act voluntarily and with the conscious intention of giving up their United States citizenship. For decades, this standard of intent made it extraordinarily difficult for the government to pursue these cases. People served in foreign militaries for complex personal reasons. People accepted government positions abroad without ever intending to stop being American. And courts generally gave citizens the benefit of the doubt. What is shifting in 2026 is not the law itself, it is the evidentiary landscape. The new dual citizenship registration framework that the Department of Homeland Security is implementing requires disclosure of foreign military service, foreign government employment, and foreign oaths of allegiance. That information, once disclosed, becomes part of a permanent federal record that is cross-referenced with immigration files, tax records, and security databases. In the past, a person might have served briefly in a foreign military during their youth and never mentioned it again. That omission was unlikely to surface unless they applied for a high-level security clearance. Now, the registration system asks the question directly, and failing to disclose creates a separate compliance problem that can trigger the very review the person was hoping to avoid. The practical reality for most dual citizens is that normal life does not trigger these provisions. Voting in a foreign election does not cost you your citizenship. Renewing a foreign passport does not cost you your citizenship. Visiting your country of origin, maintaining cultural ties, or speaking another language at home does not place you at risk. These protections remain strong and well established in case law. But the gray areas are narrower than they used to be. Accepting a formal commission in a foreign military, even in an allied nation, even in a non-combat role, now generates documentation that follows you through federal systems. And if that documentation contradicts something in your naturalization file, or your tax history, or your travel records, the system notices. The safest approach is not to avoid foreign engagement. It is to understand which specific actions carry legal significance and to seek professional guidance before taking them. Because once the action is completed and the record is created, undoing the consequences becomes exponentially more difficult. There is one more category of citizenship loss that occupies the most extreme end of the legal spectrum. It is the rarest of all, but it carries the heaviest consequences. And in 2026, the systems designed to detect it are more aggressive than they have ever been. Treason against the United States is not just a criminal charge. It is one of the few acts that can directly result in the loss of citizenship. Under federal law, a citizen who levies war against the United States or provides aid and comfort to its enemies can face both criminal prosecution and denationalization. The same applies to sedition, armed rebellion, and certain forms of espionage conducted on behalf of hostile foreign powers. These cases are extraordinarily rare. They involve deep federal investigations, classified evidence, and proceedings that can take years to resolve. Nothing about them is quick or casual. The evidentiary standard is among the highest in American law, and the person accused has every constitutional protection available, including the right to a trial, the right to counsel, and the right to appeal. But what has changed is the investigative capacity behind these provisions. In 2026, intelligence agencies, the Federal Bureau of Investigation, the Department of Justice, and the Department of Homeland Security are operating with unprecedented coordination. Digital communications, financial transactions, travel patterns, and social connections are monitored and analyzed with tools that can identify patterns across millions of data points simultaneously. For the overwhelming majority of citizens, this has no practical impact on daily life. Expressing political opinions, criticizing government policy, attending protests, and engaging in advocacy are all protected activities. Disagreement is not disloyalty, frustration is not treason, and the legal system recognizes that distinction clearly. But for anyone operating in spaces where foreign influence operations, extremist networks, or hostile intelligence services are active, the margin for error has shrunk considerably. Actions that might once have been dismissed as naive or misguided are now examined through a lens that is far less forgiving, and the consequences, when they arrive, are among the most severe the legal system can impose. The purpose of understanding this category is not fear, it is perspective. Knowing that the most extreme provisions exist helps clarify why the smaller, more common situations matter so much. The system is layered, each level of risk connects to the next. And awareness at every level is what keeps ordinary citizens from accidentally wandering into territory they never intended to enter. Now, there is one more situation that affects a group of people who rarely see themselves as being at risk at all. People who were born in the United States and have held citizenship their entire lives sometimes assume they are completely immune from any challenge to their status. In nearly every case, they are correct. Birthright citizenship is one of the strongest legal protections in the American constitutional framework. But there are extraordinarily rare exceptions, and they involve fraud at the foundational level. Cases have been documented where birth certificates were falsified, where identities were fabricated from the beginning, where organized networks created fraudulent records to establish citizenship for individuals who were never actually born in the United States. When these schemes are uncovered, and some of them operate for decades before detection, the citizenship that was built on those false records can be challenged. These cases are not about ordinary families. They are not about people who were born in hospitals, grew up in American schools, and lived normal lives. They are about systematic deception at the documentary level, and they are investigated by specialized federal units that work slowly, methodically, and with extensive evidence before any action is taken. For citizens born in the United States under legitimate circumstances, this category poses no realistic threat. But it exists in law. It has been applied in practice. And in an era where document verification technology is advancing rapidly, old frauds that once seemed permanent are being exposed with increasing frequency. What makes this especially important to understand is the psychological impact. Citizens who have lived their entire lives as Americans, who have never questioned their status, can find themselves in a surreal legal battle if their foundational documents are ever challenged. The emotional toll is immense, the legal costs are significant, and the uncertainty can last for years while the case moves through federal courts. This is not a common scenario. It is exceptionally rare. But the fact that it exists at all underscores a broader truth about citizenship in the United States. The system treats legitimacy as foundational, and when that foundation is compromised, even through the actions of others, the consequences can reach people who never imagined they were vulnerable. What connects all of these situations is a single underlying principle that the United States government has held consistently for generations. Citizenship is a privilege that must be obtained honestly and maintained with integrity. It is not a technicality. It is not a loophole. It is a legal relationship between an individual and a nation, and that relationship is built on trust. When that trust is violated through fraud, through deception, through acts of disloyalty, or through a voluntary decision to sever the connection, the law provides mechanisms to respond. Those mechanisms are deliberate, procedural, and subject to judicial review. They are not arbitrary, they are not secret, but they are powerful. And in 2026, they are backed by technology, international cooperation, and institutional infrastructure that makes them more effective than at any previous point in American history. Data that was once fragmented is now unified. Records that were once lost are now retrievable. And patterns that were once invisible are now detectable. None of this is designed to terrorize ordinary citizens. The vast majority of Americans, whether born here or naturalized, will never encounter any of these processes. Their citizenship is secure, their rights are protected, and their status is permanent. But the difference between security and vulnerability often comes down to a single factor: awareness. The people who understand how the system works are the ones who navigate it successfully. The people who assume nothing can ever change are the ones who get caught off guard when something does. And that difference, the difference between knowing and not knowing, is exactly why this information matters right now. Not tomorrow, not next year, now. The systems tracking citizenship compliance are not slowing down, they are accelerating. Every month, new data sharing agreements activate between countries. Every quarter, verification tools become more precise. Every year, the gap between what the government can detect and what individuals think is hidden grows smaller. The mechanisms described here are not theoretical. They are operational, funded, and expanding. And the window between discovering a problem and being able to resolve it is narrowing in ways most people have not yet realized. There is no pause button on federal review. Once a file is flagged, the process moves forward whether you are ready or not. If this information reached you today, it reached you at the right time. Staying informed is not about anxiety, it is about protection. Subscribe now and make sure future updates like this one find you before the deadlines do, not after. Share this with someone whose citizenship, documentation, or immigration status could be affected. The people who prepare early are the ones who stay protected. The ones who wait rarely get a second chance.